In two other cases before the courts of appeal in the same two provinces, both courts interpreted the serious personal injury in the conditional sentence context in the same way, but differently from how serious personal injury had been interpreted to date in the dangerous offender context. More specifically, in the 2009 decision by the Alberta Court of Appeal in Pontecorvo, the court held that serious personal injury in the conditional sentence context included the use or attempted use of any violence and was not restricted to only the use of serious violence. In so doing, Mr. Speaker, the court applied a different interpretation than it had to the same term in the dangerous offender context in R versus Nev in 1999. Moreover, Mr. Speaker, the Court of Appeal of Ontario in Labar in 2010 confirmed this approach and concluded that for the purpose of the availability of conditional sentences, Parliament created, and I quote, a divide between crimes where violence is or is not used, not between crimes of serious violence and less serious violence. And that is found at paragraph 69 of the Ontario Court of Appeal judgment. Mr. Speaker, what these cases illustrate is that there is considerable uncertainty about how the existing conditional sentences will be interpreted and applied. But this bill, Mr. Speaker, will provide the needed clarity and the certainty to say which offences are not eligible for a conditional sentence. This will, in turn, prevent the need to wait for these issues to be finally resolved by the appellate courts. Mr. Speaker, another concern is that the definition of serious personal injury offences does not cover other serious property crimes which would still be eligible for a conditional sentence. For instance, fraud, which can have a devastating impact on the lives of its victims, is punishable by a maximum sentence of 14 years. Although this type of offense can be every bit as devastating as a serious personal injury offense, it is still technically eligible for a conditional sentence. In addition, Mr. Speaker, the current prerequisites to the availability of a conditional sentence do not exclude drug offenses unless they are committed as part of a criminal organization and provided that they are punishable by 10 years or more and prosecuted by indictment. Consequently, as a result, a conditional sentence would be available for the production, importation, and trafficking in a Schedule I drug such as heroin. I think you'll agree with me, Mr. Speaker, that most Canadians would not find that result reasonable. Mr. Speaker, it is my view that the current conditional sentencing regime still fails to categorically make conditional sentences ineligible for many very serious crimes. Greater clarity and greater consistency is needed to limit the availability of conditional sentences and to protect Canadians from serious and violent offenders. In order to address these concerns, Mr. Speaker, this bill proposes to eliminate the reference to serious personal injury offences in Section 742.1 and make all offences punishable by 14 years or life ineligible for a conditional sentence. This would make the offence of fraud, robbery, and many other crimes ineligible for conditional sentences. It would also clearly make offences prosecuted by indictment and punishable by 10 years that result in bodily harm, involve the import or export, trafficking and production of drugs, or involve the use of a weapon, ineligible for a conditional sentence. While this element of the legislation will significantly limit the ambit of the conditional sentencing regime, the addition of these categories would not capture all serious offences prosecuted by indictment and punishable by a maximum of 10 years. So to resolve this, Mr. Speaker, this bill also proposes a list of 11 specific offences prosecuted by indictment and punishable by a maximum sentence of 10 years that, upon passage of this legislation, would become ineligible for a conditional sentence. These offences are prison breach, luring a child, criminal harassment, sexual assault, forcible confinement, trafficking in persons, abduction, theft over $5,000, breaking and entering a place other than a dwelling house, being unlawfully in a dwelling house, arson for fraudulent purpose. Mr. Speaker, conditional sentences are an appropriate sentencing tool in many cases, but access to them does need to be restricted when it comes to serious property and serious violent offences. Mr. Speaker, this government shares the common sense belief of all Canadians that the punishment should fit the crime, especially when it comes to serious and violent offences and serious and violent offenders. This legislation, when passed by this House, would make it clear to the courts that those who commit serious property and violent offences will serve jail time, and house arrest will no longer be an available sentencing option. Mr. Speaker, I hope that all honourable members will appreciate that and support this legislation. Thank you, Mr. Speaker.
Questions and comments, questions and commentary. The honourable member for Moncton Riverview, Dieppe.
I want to thank the honourable member for his speech. I want to thank him as well for, I think, opening the debate in a real fashion by saying that conditional sentences are an appropriate sentence in some cases. Because if we just looked at the newscasts, Mr. Speaker, we would think that conditional sentences are not appropriate for anything, and house arrest, conditional sentences, are synonymous, and that it's free willy, it's people can just do whatever they want. Can he expand on his comment that conditional sentences are appropriate in certain cases, and could he refer to the whole page of the menu of conditions that a judge has at his or her disposal in section 742.3 that aren't available to a judge in giving a probation order or in sentencing someone to incarceration? There's a menu there of items that might be useful in terms of rehabilitation, reintegration, cost saving, etc., that a judge might use, especially subsection 2. So could he expand on the types of crimes that have found conviction and should fall within the category of 742.3, specifically too, all those conditions about going into a treatment program, a remedy that's not available through a probation order, abstaining from the consumption of alcohol or drugs, or the very specific things that this enactment was designed to be tailored to. A convicted person who has drug problems. We know from our tour of the country and the Justice Committee that many of the people in our prisons suffer from mental illness or mental illness problems, addiction problems, and other issues that could be better probably dealt with through treatment rather than incarceration. So maybe he could expand on the list that he started talking about, but surely, I guess, did not have enough time to expand upon.
The honourable member for Edmonton, St. Albert.
Well, thank you, Mr. Speaker, and I certainly thank my friend from Moncton for his question and for the good work that he does on the Justice Committee and in this House generally. As I indicated in my opening comments, certainly conditional sentences are an appropriate disposition in many, but I would submit not all circumstances. The government believes, and certainly I believe, that when it comes to serious and or violent crimes, and by default and by definition serious and violent criminals, that individuals convicted of those types of crimes should serve their time in appropriate detention and custodial facilities and not in the comfort of their own home. But he raises a good question. All too often when we talk about conditional sentences, we're talking specifically about house arrest, but he's quite right. There are other conditional sentences that are available to the court for its consideration other than house arrest, and those can be considered in many circumstances. I believe that there are circumstances when they are not appropriate, and that was the list that I enunciated. Those, upon passage of this bill, will no longer be eligible for conditional sentence upon conviction when this bill becomes law. Thank you.
Questions and